Просмотр.
Начинаем.
Good day, Privacy Pros. We are happy to invite you to our conference about privacy in Russia from RPPA, Russian Privacy Professionals Association. Today, we will speak about privacy requirements and processing requirements of personal data in Russian Federation. And now I want to tell some words about Russian Privacy Professional Association. Association is complete of 425 members. We have 6 working groups about different directions. At today time, we spent of about 14 conferences, and we have a lot of subscribers in social media. We have more than 3,000 event visitors, and also we develop a lot of docs templates which were necessary for privacy pros in Russian Federation. And it is very excellent numbers you can see. 6,000 times these documents were downloaded. Today we have also 8 partners from another associations and communities. So RPPA is a very popular community of privacy pros in Russia. And also I want to add some words about European Data Protection Congress. This Congress is the aim of this Congress is to provide link between different associations and communities all over the world. So if you are interested in this activity, please send us an email on info@rppa.ru, and we are happy to include you to the partner list. Today, among the speakers, a lot of different specialists from different areas and company. One of the speakers is Alexei Muntyan, co-founder of this association. Marina Yufa, privacy expert from leading Russian bank. Oleg Blinov, DPO from Joom. Alena Kurbatova, in-house specialist privacy, KPMG. Irina Shurmina, privacy expert, CMS Russia. Also, there will be Ilya Pikulin, DPO Novartis Russia, and I, Chris Borovikova, co-founder RPPA and senior manager from KPMG. And to enjoy our conference, we want to tell you some case study, which we will describe and provide more details about privacy requirements. Let's start. So I am from France, and I am, let's imagine this, I am owner of a selling furniture company. We are expanding our business in Russia, and we have online local office and showrooms. We develop new website section devoted to brand development. And we have also the local office with head in Russia and marketing team using Salesforce system. Also, our accounting process managed by a local provider, and our global HR we provide through Workday system. So the question is, what necessary privacy requirements my company should bring into the life, and what requirements we should take into account? Let's ask Marina about this. I think that Marina, could you tell me please what legal basis for personal data processing I should take into account when I want to do some business in Russia Federation? Marina?
Christina, hello everyone. Christina, thanks for the introduction. Colleagues, please let me know if some technical problems with connection happen. I will try to react. Hello everyone once again. And yes, the first topic in our case study workshop that I would like to outline is legal basis for data processing under Russian law. Of course, the case that Christina outlined implies a lot of actions with data, and it goes without saying that every action with data requires legal basis, and Russian law is no exception. Under Russian law, just a second, I will test my turning pages skills. Just a second. Guys, help.
Well, Marina, maybe Alexei, can you please? Oh, thank you.
Yeah, thanks. Thank you so much. Under Russian law, well, let's start for the first. From the statement that Russian law, in terms of legal basis, there's nothing special and nothing peculiar in terms of a legal basis comparing to, for example, European law. There should be a proper legal ground specified in our key legislation, Russian law and personal data. And there are some specific areas, for example, labor code, that also outlines some special rules regarding legal basis. As I said, list of grounds is pretty similar to European law, so there would be no shock theoretically. But practically, we have some huge differences, very special differences. One of them is that our enforcement practice is completely focused on consents, and it's a big line that lies between our systems, Russian and European one. We have special rules for sensitive biometric data, and we also do have legitimate interest, but it's a kind of risky to apply. So I put on some most frequently applied legal grounds. It's consent, it's processing in accordance with laws, it's performance of a contract concluded with data subject, and it's legitimate interest. First of all, what you should be prepared to is that Russian regulator expects from you as many consents as possible, and consent is really most, I don't know, sort of easy for Russian companies to be on the safe side in terms of legal processing. We also have some problems regarding legitimate interest. We do have that in laws. We have a case law where legitimate interest is the proper legal ground, for example, video surveillance, I don't know, security in terms of entry pass for visitors. But legitimate interest is something that our regulator is scared of, and we do not have, I would say, we do not have a guidance of our regulator how to apply legitimate interest. We do not have criteria. So it's up to the company, it's up to the courage of the company if they are ready to, if they're brave enough to apply this legitimate interest or not. So the first point that we should bear in mind is that we are consent-focused system, and consent is really what regulator expects. Could please someone help me turn the page? We have a sort of system of consent under our Russian law. We have three types of consents. That is consent that can be applied in any form. So as long as it can be confirmed that consent has actually been given by data subject. There is a so-called written consent and the new consent for dissemination of data. Written consent is consent that can be obtained in a hard copy, so wet signature, or in electronic. It can be obtained electronically by electronic signature in accordance with our legislation on electronic signature. There is also some basic rules that
Marina, sorry, we have Marina, sorry, we have some sound issues. Maybe you can turn off your video.
Fully informed. Just a second, okay.
Marina, could you please turn off your video? And it may be some traffic issues. Yes, thank you. Let's continue. Thank you very much.
Okay. Let's start. Yes, let's try continue. Yes, so regardless of the form of consent, consent should be fully informed, precise, and fully given. As in European law, it may be revoked at any time. And it's interesting to note that if it happens, if the consent is revoked, data controller is obliged to terminate processing unless there are other legal grounds for continuing. I think it's very important because, for example, if we talk about European law, data controllers under European law should think twice whether they pick up consent as appropriate legal basis or not, because maybe we all remember the case in Greece in the HR context that when one of the companies were requesting consent from employees, and the regulator said that you deceived employees by giving the message that they have powers to manage their data and the data processing depends on their consent. Under Russian law, the strategy of the most companies is that they can pick up consent as a safe option, and if something goes wrong, if consent is revoked, or I don't know, maybe data subject just refuses to provide that consent, they can proceed without a legal grounds. So this is possible under Russian law, but this is not appropriate under European law. Apart from written consent, I will dwell on that a little bit further. I want to say a couple of comments regarding consent for dissemination of data. It's a real novelty under Russian law that came into force on 1st March this year. The idea behind this novelty is that when data is made publicly available, there should be a special consent that gives extra power to data subject to manage the data being made available and manage the subsequent dissemination of their data and subsequent use of the data that was made available. One of the peculiarities of this consent is close to written form of consent, but it goes further. And when you request this consent from the data subject, you have to make clear to the data subject that he or she can set out any restrictions and prohibitions in terms of further dissemination and processing of this data that you disclosed, for example, on your website. This is a law that came across as being quite outrageous because we still don't know where this, legitimate line between legitimate restrictions and prohibitions for the data subject and legitimate ones. And we still don't know. For example, as a data protection officer that put in place a special service for data consent management, I still don't know how to put into practice the requirements of that law, but that's something that we should keep a full eye on and should be prepared for. Colleagues, please turn the page, if I can ask you. Yeah, thanks. I would like to dwell on unwritten consent because it's the most frequently applied form of consent. And there are a few cases that you will came across in your practice that will require exactly this form of consent. First of all, this consent is required when you transfer employees' data. This is a special rule under Russian labor code that if you transfer your employees' data to any third party, including affiliated companies, you have to put in place the written consent of your employees. There are some in this regard. For example, what if the transfer of the data is implied by the job role that employee fulfills? What to do in that case? I wouldn't say that this is a gray line under Russian law because we have like a clarifications of our regulator that says that yes, if a job role of the employee implies that his or her data should be transferred, you go without consent. But it's just clarification, but the rule in legislation still enforced that any transfers require consent. We require consent, written form of consent for processing of sensitive data. Sensitive data, there's nothing surprising comparing to European law. It's data about personal life, it's health data. In this regard, I would say that we have a lot of problems with regard to what we consider health data, because in HR context and some other context, we need to understand whether the data constitutes health data, and we do not have a proper legal basis. So just health medical data is not only health data in terms of Russian law, and sometimes the regulator construes this quite widely, I would say. For example, if you want, I don't know, ask employees about how they feel on, I don't know, being on remote work, or any symptoms of their, I don't know, feeling, you will likely fall into the scope of this health sensitive data, and you will need written consent. Processing of biometric data is also requires written consent, and here the scope of legal basis is really narrow, because it's either biometric data required under Russian law, or it's written form of consent. Again, in practice, there might be cases of data of few years, for example, and this processing falls into the scope of their job role. For example, I'm speaking just based on my experience in financial industry, when some employees work with client biometric data, and to prevent internal fraud, you need to do some stuff with their biometric data. But in that case, we strictly would depend on data subject consents. Another classic example where we have to come across written consent and no other grounds, it's transfer of data to third countries, transnational data transfer to the countries that under Russian law do not provide adequate data protection. But I won't dwell on that at this point, because I know that other speakers will talk more about that. Well, written consent may be really a big headache for your company, because it requires to be fully informed, and you need to be really informed, and you need to comply with special rules on content of that written consent. I put on the slide just a few bullets, key details that consent should reflect. So in written consent, you should set out categories of the data. You should set out purpose of the processing. And in this regard, I would like to emphasize that we still do have a rule: one purpose, one consent. So within one consent, you strictly should set out only one purpose, or maybe, I don't know, compatible purposes, not more. Another very problematic and burdensome, I'm finishing here. Another problematic and burdensome requirement regarding this written consent is that in written consent, you need to set out details on all data processes that get access to the data. The details, I mean, their official names and addresses, and you're not allowed to, for example, just to put their, I don't know, description of what they do, of their role in the processing activity, unlike European law. So just a couple of final comments reverting to our case. I would say that, of course, in relation with the clients, the company will go with such legal basis as a contract performance. If company plans to develop a lot of marketing activities, there would be consent as a proper legal ground, but it's not necessarily, it should be written consent. I think further we'll discuss it. And since the company since the headquarters incorporated abroad, there will be a lot of issues with written consents of employees, because outsourcing of HR and other functions require written consents of employees. Processing in such resources, Workday, if I'm not mistaken, also requires written consent, because it's transfer of employee to abroad and to other party. So, guys, I'm finishing, and I think let's proceed to the other speakers. Yeah,
Marina, thank you very much for this information. I also want to confirm one more thing about my company. As I mentioned, I have local office in Russia. So according to GDPR, I can relate on legal basis, legitimate interest during the processing of personal data, for example, of employees. But as I understood you, during the processing of some kind of personal data of employees, especially when I transfer this data to third parties, I should I should use written consent. How can I handle these differences between legal bases?
Well, I think if I understood correctly your question, if you go, well, with respect to Russian employees, the only option you have to ensure the legitimate transfer of their data to foreign office from the local office is consent, because this is the rule not only of set out in our Russian law. Personal data, it's a strict special rule of labor legislation. So that's the only way. There is no room to reconcile these conflicts. You should go with consent form, written consent form. So that's why I would say that in HR context, these consent management systems is extremely important, and this is one of the key things that you should think about.
Okay, thank you very much. And I think that we can go to another main question, as we have a website. And I want to give the word to Irina Shermina. And Irina will tell us about processing data for marketing purposes.
Thank you, Christina. Thank you, Marina, for the start. So we will proceed with processing data for marketing purposes, as of course, every company is interested in promoting its services and products. Therefore, data is frequently used for marketing purposes. And I'm sure that the company we're talking about is also very much interested in this type of processing. So what we need to remember regarding marketing purposes when we deal with it in Russia. Prior consent to receive advertising is required by both data protection law and advertising law in Russia. This consent must relate to a specific advertiser or distributor of advertising, which may be a little bit different from what is common in Europe, because here, and the practice confirms it, surprisingly, even if a distributor of advertising, for example, a mobile operator, receives consent, then it can send out messages about all advertisers that he's partnering with. We're not sure that this approach will stay very long with us, but still the current practice is like this. So consent must be explicit and expressed. It can be hidden in long texts or somewhere in the terms and conditions. And this consent must be voluntary. Provision of the service cannot depend on this consent. And referring to what Marina said before, this consent should not be in a written form. It's sufficient to receive this consent in a form that you can prove that you actually have this consent. And based on the practice, it's very important to actually store and keep these consents very strictly, because in case there is some claim about some advertising that a person received, you will need this consent to be present on the case to show the regulatory authority that you actually obtained it. Also, what is necessary to remember that such consent can be received in electronic form. There is nothing in the laws that precludes us from receiving it in electronic form, but we need to remember that pre-ticked checkboxes are out of date. So there should be actual will and actual action of the data subject to actually give his consent to marketing. And it's also necessary to remember that marketing consent should be separate from other consents. So it cannot be automatically given with the consent for general personal data processing. It should be a separate one. And this is already confirmed by the courts and the regulators in Russia that this is the correct approach. So you can see on the slide, there are two tick boxes, there are two check boxes, and they are not pre-ticked. So this is the ideal sort of situation. But in Russia, we still see that not every company, unfortunately, gives this opportunity for their clients and data subjects to choose but we hope that this will change. The reason why it should change also is that as of 1st of March, we have a new piece of law in data protection legislation that says that the silence and inaction of the personal data subject under no circumstances can be considered as consent to processing of personal data. This piece relates just to one type of processing that relates to dissemination of data. But still, we see that this approach must be taken for all consents, for all data processing, whether it's processing for dissemination or any other processing, because this approach actually is confirmed by the courts. It's a bit surprising and confusing why this provision relates only to one type of processing in our law. But still, we see that this is the approach of our government and our regulators.
Irina, I have a question, yes. So it is about direct marketing purposes. So as you said, you can use an electronic form, and on this slide, you can also see in what format this electronic form can be. And what about indirect marketing purposes, such as targeting and profiling? Is it somehow controlled in Russia?
Yes, thank you. Indeed, here we're talking about such kind of marketing as SMS, for example, or emails that you receive that are sent directly. But of course, there is much advertising that we do not receive directly as a message, but we see it on social networks, for example. And here we're talking about targeting and profiling. So when a data operator, data controller receives data, and then he sorts this data and creates some kind of profiles for its users. And then he targets these users based on their preferences, their behavior, their location, etc. So this profiling and targeting, they are not regulated by the Russian law. But it doesn't mean that there is a total freedom and everyone can do everything he wants. No. Still, we have some limitations in data protection legislation. So first, content and scope of processed data must match the declared purposes of processing. So it's a purpose limitation. So if you have for example, an agreement for online sale of furniture, for example, or not online, in physical sale of furniture, then it doesn't mean that you can process this data for any purpose, including targeting and profiling, just because you received it for this kind of agreement. This processing should be limited to the purposes of this agreement. Second, processed data must not be excessive for the declared purposes. Again, if you have this purpose of selling the furniture and concluding this particular agreement, you cannot collect all other data about online behavior, about all the locations from where the website was accessed, for example. Such processing may be considered excessive. I need to put a disclaimer here that we do not see particular cases in practice about this yet, but we know that the approach is developing, and we and the regulators are looking at the European practice. And as we know, the European practice is already quite progressive in this sense, so we can expect similar approaches in Russia soon. And the third limitation is that there is a prohibition of automatic decision making if it creates legal circumstances or otherwise affects the rights and legitimate interests of a data subject. And when we talk legal circumstances, that's okay. I mean, we can understand what it would be legal implications. But when we talk about otherwise affecting legitimate interests of data subject, there can be a question. For example, if we created a profile and we decided automatically that this person is capable of paying more than another person, and then we give this person a discount of 10% while another person will get 20% discount, does it count as automatic decision that would affect the right and legitimate interest of this data subject? There is no particular answer to this question, but we see it as it might actually affect this legitimate interest of the data subject. Therefore, you need to be really, really careful with this automatic decision making. So based on what we just talked about, there are several recommendations on processing data for marketing in Russia. First is that you need to obtain prior consents for direct marketing and store them for future references. You need to avoid pre-ticked checkboxes and inclusion of marketing purposes into terms and conditions and privacy policies, and combining those when the data subject gives you a consent. Also, it's necessary to feed profiling and further targeting into processing necessary for purposes declared in consents or performance of agreement. And you should probably consider combining automatic and human processing of personal data if decisions based on such automatic processing may anyhow affect interests and rights of the person. So I think this is all from my side regarding marketing, and I'm ready to give a floor to the next speaker.
Oh, no, Irina, please stop.
I'm still here.
Oh, thank you very much. So I understood that looks like the requirements for direct marketing and also indirect are like requirements are in GDPR. So as I have a company and global company located also in France, can I use my approach of processing of personal data for marketing purposes to my local office in Russia?
I would say that most likely, yes. Of course, we need to look at your approach more closely, but in general, the approach that is used by European companies for marketing processing is more, let's say, close to the ideal situation that we would wish to have here. So in Russia, the legislation is quite broad still, but the practice is forming in the way that is close to the European approach. So I would say that presumably yes, but of course with taking into account the Russian specifics.
So, okay, thank you very much. You can use the recommendations provided on the slide and go forward and let's speak about international transfers to Russian Federation. And we want also to discuss these subjects, which is very, very important. I want to give the word to Oleg Blinov. Oleg, tell me please what requirements I should take into account.
Yeah, hello everyone. So to get back to your question, let's expand a bit the background info and add some additional details that would help me explain the requirements. If you remember, we had the head office for our ABC company in France and our local sales office in Russia. As is usually the case, the servers for the websites are in many cases hosted by AWS in Frankfurt. So here on this slide, you can see that we have a server in Frankfurt, and this is a globally available website. For Russia, our company has launched a domain name that has a .ru top-level domain, and it leads Russian customers to place orders on this website. And all the orders that are placed through the website end up in the servers in Frankfurt, which serve as production servers, so the main database. The local sales office, in order to fulfill the contracts that have been concluded through the website, they have to log into the system remotely, and they take the data that relates to Russia to their Russian customers and use the data to organize delivery. So since remote access is a form of transfer, we thereby trigger all the requirements that relate to the transfer and to the restrictions that are placed by GDPR. If you remember, Chapter 5 of GDPR says that there is a ladder of requirements that you have to follow to go through in order to transfer data outside of the European Union. The first one and the most friendly one is, of course, a transfer to an adequate jurisdiction. The problem is that the European Commission has not yet deemed Russia to be an adequate jurisdiction in terms of data protection, And one of a very important reason why it has not been the case, and one of the reasons out of many, is that our data protection authority is not independent. And unfortunately, there is a very distinct clash between the requirements of the European Union and how enforcement is structured in Russia. So Russia is not regarded as an adequate jurisdiction, so we have to turn to other measures that provide safeguards for the transfer. And as usually is the case for any transfer outside of the European Union to a country that is not adequate, is of course, we rely on the standard contractual clauses as the primary vehicle for the transfer. And all was fine and dandy until the second half of 2020, when there was the Schrems II decision. And the Schrems II decision, even though it relates to the United States, of course, did shuffle some feathers, because it essentially said the standard contractual clauses as a transfer mechanism still stand, but you have to take into account whether the recipient, the data importer, is able to provide the guarantees and essentially same level of guarantees as provided by the European legislation. And this forces data exporters to assess the legislation of the data importer, and maybe if the guarantees are not met, provide supplementary measures. So the question is essentially, do you have to place supplementary measures into your STCs in order to transfer to Russia? Now, the primary source for you to respond to this question and to start your analysis is an analysis that was done by Konstantin, one of the members of our associations, which you can find on the essentialguarantees.com website and by searching for Russia. But to keep it short and simple, we have a so-called Yarovaya law, which is named after one of the members of the Russian legislature, which as part of an anti-terrorist package said that, well, telecom providers have to keep data for 6 months and metadata for 3 years, which is quite extensive in terms of how data is handled. Furthermore, enforcement authorities have quite broad powers in terms of what they can do, what they can request, and transparency to data subjects and to data controllers is not always met in this case. Furthermore, even if you believe that the enforcement agencies somehow abuse their powers or overstep their limits of powers in terms of requests of data, unfortunately, the oversight and remedies that are available are not that strong. So all in all, the inadequate assessment would be that Russia is not meeting all the requirements that are set by the European Union as a baseline for the transfer. So this forces us to move into the question of supplementary measures. And the primary source for you would be, of course, the European Data Protection Recommendations 01/2020, which were published in, I think, November last year, which explain not only what an international transfer is, but in their annex, they provide different types of measures that you can use as a supplement to the STC. And they are broken down into 3 categories. The first one being technical, and this is regarded as the most bulletproof type of supplementary measures. And of course, encryption in transit is of course the bare minimum you can do. Furthermore, you can add additional types of technical protection, like the devices that receive the data from the European Union should have disk encryption enabled. Furthermore, you can supplement the technical measures that you've already taken with contractual and organizational measures, and some of them are placed on this list. And depending on your situation and the situation of ABC here, you have to assess what should be done in each case. But one of them is, of course, for example, transparency for the data exporter. If you place a mechanism with the data importer that triggers when someone has access to the data and passively notifies the data importer, that's called a canary. That's a very effective means of how to let at least the data importer know what is being done to the data. There's also, for example, organizational measures you can take, example being data minimization. So you periodically clean up the data storage in order not to subject to the risks all the data that are being handled by the Russian sales office. So all in all, to sum up, the Russian Federation is not yet fully up to task of protecting data as well as the European data protection agencies and the legislation does. And we have to take supplementary measures. That's a very good practice. It not only frees you from the risks of international transfers, that's also a very good measure in terms of technical protection under Article 32. So supplementary measures is a way to go. You have to do the analysis and come up with supplementary measures such as these. That'll be all from my side. Do you have any questions, Chris?
Yes, of course. Thank you very much, because I'm thinking about the choosing of legal basis for transfer. And to be honest, I wanted to choose standard contractual clauses. And according to information of you, yes, I should implement additional measures. And maybe you know, is it common practice for enforcement bodies to send requests for disclosure of personal data?
Mm-hmm. This very much depends on your type of business. If you're just a B2C business or even a B2B business, just selling like fidgets, then most of your requests will be placed by enforcement agencies asking you for details regarding fraudulent payments through your website. And this is not something that much invasive into your data privacy, but you still have to look into that. Additionally, you have to take into account that if your main type of business is handling of information, for example, if you're launching a social network, then your exposure to data requests will be much higher, and you have to take this into account as well.
Okay, understood. So also these technical and organizational measures, which I apply during the transfer to Russia. And as you know, I have also third party, which I involved to process accounting information via accounting process. So should I put these measures to this third party also to the contractual clauses here?
It kind of depends on how your data flows are structured, because if you engaged a company for accounting, for example, for HR purposes, then the information does not stem from the European Union. It's the data of your local office, and it doesn't really cross the border. So it is very much dependent on what your contractual structure is within the group.
Okay, and one more question, I think this is the last. So when I choose the appropriate technical and organizational security measures, should I take into account our global information security policy, which are applicable to my office in France, for example? Or maybe I should also look to the requirements which are applicable to the Russian Federation and listed in the local law?
Yes, you should, of course, take both of these into account. However, I think this is a slightly different areas of compliance, because in Russia we also have an a similar provision to Article 32 of GDPR, which asks you to introduce the necessary security measures, and thereby you're addressing the risks to data subjects in terms of how their data is protected. With supplementary measures, this is they touch each other, but they're not fully the same, because you are here not protecting against any types of, for example, internal risks. When doing the SEC supplementary measures, the main thing you're protecting yourself from is the engagement of authorities, and that's a different risk profile. So a person who develops the technical safeguards for the SEC should, of course, consult these papers, but should not limit oneself with these.
Okay, thank you very much. So I will have
You're
a lot
welcome.
of headache. There will be a lot of headache for my opening local office in Russia, because as we discussed, there are some requirements for legal basis, which are different from GDPR in some cases. Also some requirements for marketing purposes, as we discussed, and a lot of headache with transfers. So I think that it is not end, because we will go to another one headache called transfers from Russia abroad, and it is not end. Yes, I want to go for Alona. Alona, please tell me, what additional measures should I implement in my organization located in Russia when I want to transfer, for example, information to the office located in Frankfurt, for example?
Okay.
I have a service, yes, here.
Yeah, thank you so much, Chris, and thank you, Oleg, for deep dive on this topic for international transfers. And I would give you a set of recommendations for sure on how to transfer data from Russia, and explain how should law-abiding business such as yours, Christina, company ABC, organize the data transfer under Russia-specific legal conditions, and you will see they're really specific. So, to begin with, let's start with the definition. What is cross-border transfer of personal data? It comprises of some elements. It's a transfer of data to foreign state, or to foreign state agency, to foreign national or legal entity, as in our example. In general, transfer of personal data abroad is allowed, but given that certain restrictions are met, and prior transfer of personal data outside Russia, the person, the company must ensure that the recipient state provides for the adequate protection of personal data. What does it mean? Well, the adequate protection means that the recipient state either ratified the Strasbourg Convention, and or the company, the country refers to so-called whitelisted countries. It is the list, special list, which is official and adopted by our regulator, the Data Protection Authority, Roskomnadzor. And this list includes 23 additional countries, and here we provided some examples of such countries like New Zealand, Canada, Australia, etc. And what is important as well, the purpose of cross-border transfer must be in line with the purpose of the initial collection of personal data. So if all these requirements are met, then you should be safe and you could transfer data abroad, and do not worry for some negative consequences that you might face. But that's not the end. We had the situation where the country where the data is transferred provides for adequate protection of data subjects' rights and interests, but for sure, you can transfer data somewhere, not in Frankfurt, but for example, in the USA, which are considered inadequate countries in this sense. What could be the prerequisites of transfer, of such transfer? So where there is no adequate protection, cross-border transfer is permitted if one of the following conditions that you see on the screen are met. The first one is if the data subject provides for his written consent. Yes, we do love consents in Russia, actually. If the transfer is provided for under the international treaty to which Russian Federation is the signatory, then if the transfer is necessary in accordance with federal laws for protection of the constitution, state defense, security, and transport system, and if such transfer is required to protect the data subject's life, health, or some other vital interests, and it is impossible to obtain the prior written consent in writing from such individual, But there might be some restriction, and important is the fact that under Personal Data Act, the law on personal data, the cross-border transfer may be prohibited or restricted. For which purposes? Sure, for the purposes of protection of the foundations of constitutional system of the Russian Federation, health, rights, morality, and lawful interests of the citizens. And just in short, these are the prerequisites of cross-border transfer and some requirements that you may face in dealing with such kinds of transfer from Russia. It's in the broad sense, but some peculiarities would be on the next slides of the next speaker. Chris, do you have any questions?
Yes, of course. It is really not easy to understand the transfers from Russia, and I have some questions. Let's begin. Which mechanism do companies normally use to transfer personal data abroad, subject to applicable transfer restrictions?
Well, typically, as I mentioned, companies that are acting as data controllers or operators, as we call it's under our regulation, they would verify whether or not the country to which personal data transferred is a party to the Strasbourg Convention or included in the list of these whitelisted countries. And if the initial purpose of data collection corresponds to the purpose of the data transfer. If these requirements are not met, then, and the country is not adequate in this sense, then you should, normally the businesses would provide for the written consents of the data subjects, and to ensure this cross-border transfer. And they would execute agreements on personal data processing with the third parties to whom the personal data is transferred. And then after that, they may proceed with cross-border transfer in accordance with some regulations, policies, like that.
Okay, thank you. And as I understood, the transfers also in another personal data processing activities are strictly regulated in Russia. And so do cross-border transfers require prior approval or notification of the local data protection authority?
Well, in general, personal data operators must just notify Roskomnadzor on data transfer, international data transfers that they have in their operating their business, but you do not need the prior approval or on cross-border transfer or enter into special agreements. However, you should just notify the Roskomnadzor such transfer prior conducting such transfer for the purposes of registration in the register of data operators, because we need to register before that. But special authorization is not required.
So as I understood, for my company in Russia, I should notify supervisory authority via some form, which I will send to this authority, and I should understand what data transfers are performed from my company to abroad.
Yeah, that's right. You should make a list of the operations that you carry out, like data processing operations, and you should understand which countries you would transfer personal data to, and make this list and notify the regulator.
Okay, thank you very much. I think that I perform the inventory of data assets as I perform in my friend's company, and maybe some records of data processing activities will be also helpful for this case. Thank you very much.
For sure.
And the most important and famous and popular question in Russia is about data localization. I think that is very you are waiting this topic, and it is we will share our issues and our knowledge about data localization requirements. And I want to call for Alexei Muntan, and he will tell us what data localization requirements are and what measures we should take into consideration. Alexei.
Yeah, thank you, Chris, for that. And so I will try to keep the story, relatively short, because the data localization law is with us like almost 6 years. So it came into force at the 1st September of 2015. And now many companies which are doing business in Russia, so companies which originate from the Russian Federation, and companies which are daughter companies or branches or rep offices of the international companies. So they are all facing the same challenge. And this challenge is called data localization requirement. And so we have this requirement in the Federal Law 152 FZ on personal data. So it's part 5 of Article 18. And so you can see on the screen the exact wording of this requirement. And at glance, it is quite hard to put together all the requirements. And I just did my best in terms of just showing you what are the main conditions in order to follow this requirement. So in case of collection of personal data, including means of information and telecommunication internet network. So the data controller is obliged to ensure the number of activities with personal data of Russian citizens using database which are located in the territory of the Russian Federation. And as I was saying, so at first glance, it is quite simple, but when we go into details, so it's to some extent it's quite hard to understand what exactly this does mean. I mean, in terms of like particular data processing activities. And but please be sure so that you're not alone. Many companies and many consultants, so many data privacy experts, they are struggling in order to understand what exactly you should follow. I mean, what are the rules? And but first, and really important question is to understand what is the scope of this requirement, because many companies have many systems with personal data, and so it's quite hard to identify what information system and what database falls in the scope of personal data localization law. And so I also did my best try into understand that, and according to all comments and clarifications which were made by Russian Ministry of Telecommunications and Information and Russian Data Protection Authority, Roskomnadzor. So according to their explanations and clarifications, so I have made this slide, which shows 8 sources of personal data, which could be relevant for each data processing activity. And according to my estimation and my analysis, only 3 of these 8 are false in the scope of personal data localization law. So it's when the data is given by individuals or their representatives. So when you are receiving personal data directly from a data subject. So, and this could be done by you as a data controller, or this could be done under your supervision and under your assignment if you're engaging in this process another company, another entity, or some other body as a data processor. The second case is when you are processing so-called disseminated data. So the data which is captured from publicly accessible sources. So you can see the example like social network account exploration. And the third case, when you are dealing with observed data, so the data which is recorded by monitoring of individuals' behavior, like online tracking, geolocation, or CCTV, so whatsoever. And this is quite important because there are 5 other sources of personal data which are not in the scope of personal data localization legislation. This is quite important because it's not so well. It's so good approach. Try to localize all your information systems, and in many cases this will be just impossible because you are as a part of international company, and we are dealing the case when the company ABC is having their branch or rep office in Russia, but the main IT infrastructure is located in Frankfurt in Germany. So for us, it will be impossible to follow this requirement. So we have to identify the systems, the local systems, which should be tolerated as in the scope of personal data localization. And so for us, it will be good to make like a exercise. So we have to make a decomposition of data sources for each system. And here on this slide, you can see the example of this decomposition. So it's all about the training process. I've choose this activity because I think it's well known and really widespread among all countries. So you can see that if we go through the whole process of training, so we can identify 4 data sources, and only first 2 steps falls in the personal data localization law. So when we are making a training registration, so it could be qualified as collecting of provided data. So the second stage, when people are attending training, so you can make attendance tracking. And so this is observed data. So those 2 sources falls in the personal data localization legislation, and so these data have to be localized on in the territory of Russia. But to other stages, so test result calculation and certificate awards, this information could be stored directly in the foreign database or abroad. And so using this concept, we can save quite a lot of fortune, a lot of time and labor, because we have clear understanding that not all of our data processing activities have to be localized. So we would be really happy just to save all these resources and to invest them in the direct business operations here in the country. And this is really important. So I've just made this identification scheme. So you can just follow these 6 simple questions against all systems which you are planning to distribute or to create here in Russia, and or to use for Russian business operations. And hopefully it will help you. I mean, because this is quite simple. Of course, it's not 100% convenient for you. I mean, in terms of just having clear understanding, but anyway, so it's really helpful initial analysis at glance. I mean, just to understand which systems are in the scope or not. So, and of course, when you have clear understanding, so that like a given system is in the scope of personal data localization legislation, so it's a new challenge just to understand what kind of strategies or concepts you should follow in terms of make your decision in terms of the personal data localization compliance. And I must say that there are also 8 strategies which are theoretically possible for you to choose. But the main the main message of this slide is just to be quite careful with choosing the strategies, because they are not having the same level of legal risk, and in terms of not cry over spilled milk under the bridge. So I strongly recommend you to have a deep dive in each strategy and understand if it's suitable enough, and to find a balance between risks and benefits for each given strategy. And,
okay, Alexei.
Yes, please. Yes.
So thank you very much. I think that there is quite enough 8 concepts. It's very difficult choice from the described. And which concept are the most popular among companies in Russia? Maybe you can advise me what or one of these I can choose.
Yes, gladly. Thanks a lot for your question. So I must say that here in Russia, well, I think one of the most popular strategies is strategy number 7. So strategy, which is so-called making an interim database. And here on this slide, you can see how this strategy could be implemented regarding our case. So when we have an ABC company, which is located somewhere in France, and so they have a local sales office in Russia, and also they have a global IT infrastructure located in Germany. So if you would like to follow this strategy, so you can make like a local Russian database or local Russian instance, where you have to create, read, update, and delete all personal data, which is collected from Russian citizens. But after you made this initial data localization, so you can immediately make a data replication to the central database instance in Germany. And then, so this information could be shared with other global applications, which is used by the ABC company in France, or in their maybe affiliates or data companies in other countries. But of course, following this concept, you have to be also careful and bear in mind all requirements concerning Russian cross-border data transfer legislation, which was described by my colleagues previously. So hopefully I have answered your question.
Okay, also thank you for the scheme, but I didn't budget the cost for additional database. I think that I can only transfer personal data as I want to transfer previously and without any localization requirements from my side to be done. What is the risk for my company in Russia if I do not use the 7th implementation case, for
example? In order to make long story short, so we have a couple of examples here in Russia when companies were fined for the non-compliance with personal data localization legislation. But the number of cases is relatively small. But some companies like LinkedIn, they have faced their business operations termination in Russia because their website was just banned by Russian Data Protection Authority, and this decision was upheld by a Russian court. And some companies like Facebook and Twitter, they were fined. Well, the fines was also relatively small, something like up to $65,000 each for each company. But anyway, I mean, if you really would like to save your budget, I strongly recommend you not to accept those risks, but try to mitigate them. So that is my main recommendation.
Okay, Alexei, thank you very much. I will consider the proposed approach by your side. And the last but not less important is the subject. We will discuss the subject connected with accountability issues. And yes, there are a lot of requirements, as we discussed. You should implement consent or maybe another legal basis. Maybe you should make some policy, should make some transfer requirements into life. And what about accountability, for example? Should I put some documentation in my company? How a lot of documentation should be, and what about the view of supervisory authority during the inspection? I want to call for Ilya, and Ilya will share with us his practice and knowledge about accountability.
Okay, thanks, Chris. Hello, everyone. So thanks a lot for the ability to talk here on this platform. And yes, I would like to say something on the accountability part. So it is necessary to understand that it is not possible, to cover everything here. So I will just try to highlight the most important points to be considered. So yes, we have a local agency which tries to control everything in the field of personal data processing. And so this is, it called actually as Roskomnadzor. This is a part of Russian Ministry of Communication and Digital Development. So unfortunately, it's not so-called independent. So it is like governmental agency. And that is why sometimes we face some misconnection with such agencies, when we talk about the compliance with the law, so from different perspectives. So, and This agency, of course, has quite a big list of responsibilities, but I would like to highlight the most not critical, but the most relevant points to be considered, as I already mentioned, and I will not try to talk about the main things which are related to other countries as well. For example, it is necessary to remember that Russian legislation is originally based on the European one, and for example, the requirements that which we have in GDPR, the most of them related to accountability, of course, are also related to Russian legislation as well. So the first point that I want just to mention is that Russian DPA actually maintains the list of data operators or data controllers. So, and the very important point for all data controllers to notify data protection authority on the data processing. So there are some special there is a special form on the website of Roskomnadzor to be fulfilled in case you would like to notify data protection authority, and you have to inform data protection authority about some specific things. For example, there should be information related to local DPO, and it is necessary to remember that Russian companies should have data protection officer, and every single legal entity should have data protection officer, and this is one of the main difference from the European legislation. Also, this notification form should have information about international data transfers, which was already mentioned by my colleagues here. There should be information about the actually location of databases where the data is being processed, and it is very important point, and quite interesting point, because you know, in the new era of the clouds, so sometimes it is really hard to understand the particular address of the particular server where the data is located, but you know, we have what we have. So you can conduct this notification and to be registered as data controller only in case you understand the scope of data processing in your company, only in case you have audited your internal processes on data processing. And it is really important to understand that in case you decide not to notify a data protection authority, it doesn't mean that you are not visible for them. So they still know that there are some, you know, there is some list of organizations. They understand the areas where your organization could possibly work in, and so sometimes it is better to notify than not to notify. So another main area of responsibility of data protection authority here in Russia is to manage data subject complaints and requests, and it is something that which is also very clear to be followed by the data controller here in Russia, is to process all requests and complaints that you could possibly have from data subjects. Fortunately, in Russia, the culture of data protection is not so high. Fortunately for data controllers from this perspective, but not for the country, unfortunately. And we do not receive a lot of requests. We do not receive a lot of complaints from data subjects, and it is quite easy to manage all this stuff and to be able to provide responses in very short periods of time, which is also determined by a local law. And you have to do it because in case you decide not to do it, a data subject will go to data protection authority, and you could face some requests from their side as well, and you could face some unplanned inspection from their side. So, and which comes to the next important point, my responsibility from that is related to data protection authority, that they are conducting data protection inspections. There are different types of inspections, and the most common, frequently facing one is that data protection inspections tries to conduct so-called systematic observations or systematic screening of the websites which are located in the internet. They try to identify websites which are used for data collection, and they're checking whether the collected data is okay with the original purposes. They're checking whether the website has privacy policy in place, and in case there is no privacy policy in place, they will trigger some requests, some more specific requests to the data controller to check additional information, and in the most of cases they will try to how to say to highlight that it's not possible to collect data without privacy policy in place. Another and the most common inspection type that we face is so-called planned inspections. So every single December, the Data Protection Authority publish the plan for the next year for the inspections of data controllers. So usually the list is not very big, and they are not intended to conduct a lot of inspection during calendar year. However, it is necessary to keep an eye on these publications on this list to check whether you're in scope for the next year or not. And you have to be prepared for such kind of planned inspections, even if you are not expect to see you in this particular list, because sometimes this list of planned inspections, they're published, as I already mentioned, in December, but there could be inspections conducted in January. So you do not have a lot of time to be fully prepared for such kind of inspection. And you have to understand that all documents which are required by the law, all processes which are required by the law should be implemented beforehand. You have to be prepared in advance. So, and how you can be prepared? So, of course, I will not be able to list out all documents that you have to work out before. They're the most common things which are also related to GDPR. For example, you have to complete and to maintain the list of processing activities. You should have the list of data subject requests. You should be able to provide enough information about data protection, which is also very much important point from data protection authorities. They ask questions on data protection, but they not go really deep in these questions. However, they are asking on this point because we have quite strict requirements related to data protection. Unfortunately, they are not very much risk-based. They're related to some specific information which is processed by the data controller, and there are some specific so-called levels of security that should be implemented. So you have to be prepared in advance from this perspective as well. And of course, there could be some unplanned inspections in case of any complaints or any sometimes even political reasons. So you should be prepared in advance, even you are not in the list of inspections.
Okay, Ilya, thank you. So as I understood, if I create a legal entity in Russia, and maybe if I have a website which are visible in Russia Federation and in Russian language, I will be under the control of local supervisory authority, and maybe there is a risk that my entity will be in the list of the companies which maybe are under the inspection. And what kind of consequences will we face, my company face, in case we decide to ignore applicable requirements? Because as you tell us, there are a lot of documents which should be implemented, and as for me, it's very time consuming.
Yes, thanks a lot, Chris, for this question. So there are some fines. There are some other restrictions that could follow in case the company doesn't comply with the legislation related to data protection. Fortunately, also for Russian data controllers, the numbers related to fines are not so significant like in GDPR. Then these numbers are not related and connected with the annual revenue of the company. However, they could be quite important for the local, at least small company. For example, in case we're talking about the violation of some specific basic data protection requirement, for example, the processing of data with no written consents collected when it is required, and it was the written consent was mentioned more than twice here today during this webinar. There could be fine for a repeatable violation up to more than 5k euro, and So, and it is still not clear whether this fine will be for the common violation or for the violation of like rights and freedoms of every single data subject, and could be multiplied by the number of data subjects sourced. So we didn't have such practice before, but every single time Data Protection Authority during seminars and other events, they are trying to highlight that this practice could be implemented, and all fines could be multiplied by the number of data subjects. This is about like common data protection requirements, and also there is a separate area which is related to violation of so-called data localization requirements. And here we see much more significant fines. And here we could face up to 200k euro for the repeated violation of so-called localization requirement. And this is quite new practice that we have in Russia. It appeared to us just, as I might remember, 2 years ago, so quite new. But we already have some cases, and I will mention them a bit later. But not only the fines are quite important for point from this perspective. Some cases, Russian data protection authorities, together with courts, together with prosecutor's office, they are able to implement additional limitations. For example, they could block the website to make it not visible for a Russian audience. And also, in case we are talking about violation of some requirements related to the websites. And also in some rare cases, there were situations when court, together with the protection authorities and the prosecutor's office, was able to limit and suspend the activities of the whole organization for up to 90 days because the company decided not to follow the order from prosecutor's office twice, and that's why it was possible to implement such kind of restriction for such company.
Okay, it's really something frightening, I think. As mentioned, Alexei, for example, about case connected with LinkedIn, I think it is very popular case, and everyone from France and from another countries, my colleagues, they also, when speaking about localization requirements, they mentioned about LinkedIn case. And just I have asked you as a subject, you also, as I know, subject of personal data, as you're located and you're citizen of Russian Federation, maybe you have some troubles connected with usage of LinkedIn, and maybe such restrictions connected with social media, social network, which your regulator take into practice, very have some trouble for users, for real users. How do you handle usage of LinkedIn?
So actually, you already mentioned that we had some examples when these restrictions were in place. When we talk about LinkedIn, it is still blocked. It was blocked in a couple of years ago, and it is still blocked. And of course, such kind of restrictions, it really creates it really creates trouble for the company locally. It is still possible to find workarounds how to get access to such websites, but you really need to have a clear will to do it, because you have to use some kind of VPN, some external networks, and which is not really useful, and which is not really comfortable for the most of citizens here in Russia. So and it is necessary also to remember that in case of LinkedIn, the Data Protection Authority just blocked the website and that is it. No, they already restricted the usage of the application of that LinkedIn had in different stores, for example, in App Store for Apple devices, in Play Market for Android devices as well. So you cannot find these applications in these stores anymore. So, and it is really limitation that matters for the company. And also we had quite recent cases related to the fines to Twitter and Facebook, and actually these fines were related to the violation of localization law. So it is something that also works. They were not so significant as I mentioned before. There were just $63K fine for each company. But for all these cases, for Twitter, for Facebook, for LinkedIn, I see the main issue that the company didn't want to communicate with Data Protection Authority. They didn't respond to the request from Data Protection Authority, and that's why they faced these troubles. Because I know a lot of cases when big companies, they had issues with data localization, they had issues with some other requirements related to Data Protection Authority, and they were able to find a way how to decrease the level of how to say severity here from circumstances perspective, and they were able to find some level of collaboration of data protection authorities, and they do not appear in the list of the fines from data protection perspective. So my recommendation to you and to other companies who decide to work in Russia, please be open to the request from data protection from the request from Data Protection Authority. Please try to find a way to communicate with them, because even when you are in the inspection, you're able to be a bit more flexible managing your internal systems, for example, to adjust the data the processing activity right during the inspection, and the data protection authorities will accept these changes, and they will not highlight and they will not provide you with any fines related to this possible violation. So
thank you. Thank you, Ilya, very much. And I want also coach for another speakers to connect with the video and to say goodbye to our auditory. And I want also to tell you something about RPPA. So you can find this presentation on our website, and also we will try to share via LinkedIn. And if you have some questions regarding Russian privacy law, you can send us messages via LinkedIn and other social networks. So we are open to discussion, and we representing here the community of Russia, and we are very happy to share our knowledge with you. Thank you, everyone, and be very careful by processing personal data in Russia. There are a lot of requirements, and as you heard, today we speak about requirements of legal basis of processing, transfers, data transfers to Russia and from Russia. Also some marketing purposes, processing personal data, and of course, localization requirements. And it is not the end. We have also very strict legislation in connection with information security measures, which you should put in place. And if you have questions, and if you want to cooperate with us, with our community, or with our speakers, please send us a message to info@rppa.ru, and we're very happy to cooperate with you. Thank you, everyone, for attending today's conference, and I wish you luck and I wish you health. Please keep your health and keep you safe in this time. Thank you very much, and bye.
Yeah, Christina, yes.
Thank you, everyone.
Yes, yes, guys, sorry. I think we have one question in the chat room. So
okay.
one of the participants, he's asking a practical question. So if the person is leaving foreign company, for how much time it is allowed to store personal data of this person in the corporate systems hosted inside and outside of Russia? So who would like to take the floor and answer this question? Guys, please.
I can try if my connection
yes, Marina,
still
please.
Okay. So if I understood correctly, the person being employee leaves the company. The question is the time frames of processing after his exit, right?
Yep.
Well, that's, well, how to put it correctly in English, that's my headache, being data protection officer, majoring in HR projects. Actually, it depends on the purpose of the processing. So the most of HR related purposes of the processing, they should stop, they are enforced as long as the employment relations is enforced. So if a person resigns, the processing should stop within our classic 30 days. But actually, I don't know, I'm pretty sure that the company of that person likely asked for consents that set maybe longer time frames, for example, I don't know, for analytical purposes, monitoring purposes, and so on. So the processing will likely be longer than will continue after exit of that person. And plus there is archive. There are archive terms of storage. So just by virtue of Russian law, some data should be stored just, yes, by virtue of this regulatory requirements regarding archive. I hope it sheds light on the matter.
Yes, Marina, thanks a lot. Thanks a lot for your question. And as Christina was saying, so in any case, if you have any other questions, please do not hesitate, just email us and we will be glad to provide clear and full answers to all of your questions. And thanks a lot and wish you all the best and see you on our meetings and webinars. Goodbye.
Bye-bye, everyone.
Thank you. Goodbye.
Thank
Bye.
you. Bye.
Bye-bye.